Hello, everybody. This is two of the three documents that were filed on the 24th of June. First one being this defendant's joint motion to restrict, pursuant to General Local Rule 79, Laura Riccardi, More Demos, Chrome Media, LLC, together producer defendants, joined by co-defendant Netflix, collectively defendants, submit the motion to restrict motion in connection with the joint civil LR7 expedited non-dispositive motion for order allowing defendants to depose plaintiff for 14 hours collectively. Although defendants filed this motion in compliance with Rule 79D for the reasons set forth below, defendants object to restricting public access to the deposition expert identified below. In support of their deposition, defendants states as follows. On May 20th, 2022, counsel for Netflix deposed Brenda Schuler, Andrew Colborn's close confidant and executive producer of convicting a murderer. During the deposition, the parties agreed to treat the entirety of the transcript as confidential and, as with other depositions in this action, to seek permission from relevant counsel to file excerpts of the transcript publicly. During the deposition, Ms. Schuler testified regarding various topics that defendants must now question Mr. Colborn about during his forthcoming deposition, and to illustrate for the court why defendants require 14 hours collectively to depose Mr. Colborn. Defendants have attached several relevant experts from Ms. Schuler's deposition transcript regarding these topics. On June 23, 2022, counsel for producer defendants sought agreement from plaintiff's counsel and counsel for Ms. Schuler to file publicly these deposition experts. Plaintiff's counsel consented to the de-designation of the public filing of all experts. Counsel for Ms. Schuler, however, did not consent to the de-designating the subset of these experts, namely pages 341 through 48. Though consistent with the de-designation of the remaining experts, defendant do not believe the expert identified Ms. Schuler's counsel is confidential as contemplated in the protective order, which permits distinguishing confidential only those documents that a party in good faith believes contain trade secrets, non-public, confidential, technical, commercial, financial, personal, and business information. For all the reasons herein, defendants object to the restriction of the pages 341 through 48 of Ms. Schuler's deposition transcript and respectfully request that the court deny this motion and publicly file their motion and all related papers. And the other document filed today, which is 5 pages. The first one was 3. Defendant's joint civil expedited non-dispositive motion order allowing defendants to depose plaintiff for 14 hours collectively. Defendants Laura Riccardi, More Demos, Chrome Media, together producer defendants, joined by co-defendant Netflix, collectively defendants by their attorneys, hereby move the court for order granting defendants leave to depose plaintiff Andrew Colborn for 14 hours collectively, 2 days and 7 hours each, pursuant to federal rules, civil procedure 2630-37. Defendant states as follows. There is good cause for this motion. Rule 30D1 limits the deposition to 7 hours, but requires that the court to order otherwise additional time needed to fairly examine the deponent. Committee notes for the 2000 Amendment Rule 30 explain that extension may be warranted for questioning about events occurring for a long period of time. Multi-party cases, numerous and lengthy documents, so long, duplicated questioning is avoided. Plaintiff filed a multi-party lawsuit against defendants and it is made clear in discovery he seeks to recover more than $10 million from them. His second amendment complaint, in 56 pages long, involves myriad allegations about events that occurred as far back as 1985. His response to interrogatories from the producer defendants run nearly 70 pages. The responses to Netflix another 15, and he produced thousands of pages of documents of hours of audio files, while also denying nearly every request for admission. In addition, Third parties, including plaintiff, former employer of Manitowoc County Sheriff's Office, and the Calumet County Sheriff's Office, provided tens of thousands of pages regarding underlying events and issues in making a murder. An ordinary defamation case might involve a single statement or a short article. Here, MAM is a 10-hour series documenting decades of events. Plaintiff, actually it's 20 hours because there's 2 seasons. Plaintiff has sued for both defamation and intentional infliction of emotional distress, listing volumes alleging falsely and defamatory statements, while also complaining about the series emissions, musical score. He complained about the musical score? So how do you complain about a musical score when you just read a transcript or in graphics? All right, Andrew Colborn. Defendants must explore all in order to adequately and fairly defend it themselves. Plaintiff took 4 full-day party and our party-affiliated depositions defendants Ricardo Nemos, Netflix employees Lisa Mura, and Adam Del Dio. By contrast, defendants have only one party, plaintiff, to question about the multitude of allegations of the SAC and the contentions of the documents adduced in discovery. Defendants must have adequate time to address the various elements of plaintiff's claims, including the range of allegedly materially false and defamatory statements on which plaintiff's SAC is premised, and the underlying facts related to such statements, the extent to which statements were first made by the defense team for Mr. Avery's criminal trial and controversially reported on by the media, actual malice of plaintiff's contentions regarding the same, the damages plaintiff claimed to have suffered, proximity causation of any such claimed damages, including through publicly surrounding Mr. Avery's criminal trial, defendants' alleged intent to cause emotional distress or lack thereof, to mitigate and claim damages, including exclusive contact entered into with convicting a murderer, forthcoming counter-documentary to MAM. In addition, defendants must question plaintiff regarding various revelations from recent deposition of Brenda Schuler, Mr. Colborn, close confidant and executive producer of convicting a murderer, including where plaintiff preserved and produced the defendant's all documents responsive to discovery requests. Ms. Schuler testified plaintiff provided to her a box of materials. Plaintiff's violation of confidentiality in this case. Ms. Schuler testified, and it's redacted, that whatever that might have said, and defendants worry plaintiff may have committed other violations, including with respect to proprietary materials produced in discovery. The producer defendants worry he may have shared with others an extent to plaintiff's waiver of attorney-client privilege. Ms. Schuler testified that, although not part of the plaintiff's litigation team, she drafted portions of his complaint, including the lengthy exhibits that communicated extensively with plaintiff and Michael Griesbach about preparing the lawsuit. She concurrently filed a declaration of Kevin L. Vick, excerpts from B. Schuler deposition. In short, there's a lot of asked the plaintiff about his deposition. Accordingly, the defendants respectfully request that they be granted collectively 14 hours to depose plaintiff over the course of 2 days. This is reasonable under circumstances detailed above. Nothing that the 7-hour limit is only presumptive. Additional time must be allowed if needed. Fairly examine the defendant. Counsel for plaintiff opposes this motion and has refused to consent to advance to additional time to depose plaintiff, agreeing only that if, after 7 hours of questioning, they believe defendant's questioning had been efficient or non-duplicative, they would consider allowing some additional time. Defendants cannot produce under such uncertainty, as all defendants need to know in advance how much time they have to question plaintiff and plan accordingly. Defendants cannot leave things entirely in the hands of the plaintiff counsel to utterly decide the length of the deposition. Defendants also fear a wait-and-see approach risks completing the case schedule by a necessary future motion practice in August. A copy of the parties' meeting conference correspondence is provided concurrently with the motion. Vic, example 2. And yeah. The next one is 40-something pages long, so I have no clue what it says because I read these documents in real time, so I'll be back.